Good morning. We are here live. I'm Aaron Hall, an attorney for business owners and entrepreneurs. And today on this educational YouTube channel, also live on various other social media platforms. Please keep in mind your questions on here are public, which means when you ask them, they're out on the internet. There's no confidentiality here. Today, I'm going to cover the questions that are most important to you first. And then I have a number of other questions that have come in this past week, and we'll cover those second. Chazzy's channel is here. You know what? I have a question from you. Let's jump down to that right now because I saw you submitted that one in advance. All right. What should I do if I had already been using my name for 10 years as a registered business and filed a trademark, but had to file extensions due to funds? So I assume that means perhaps limited funds. Meanwhile, two other companies in the same class filed similar names, and one of them took my labeling layout. What do I do? Let's talk about some of these terms here, because if a person is new to trademark law, you may not fully understand what all this means. So Chazzy's channel is saying, look, I wanted to register a federal trademark. We don't worry about state trademarks because federal trademark law trumps state trademark law. So I assume this is a federal trademark application. Once you file a federal trademark application, or as part of the filing, you need to show that you're actually using the mark in commerce. Why is that required? Because under constitutional law, the federal government doesn't have the authority to regulate trademark law unless it relates to interstate commerce. It's under the Commerce Clause. So as a legal requirement, federal statutes require that there be interstate commerce. Chazzy, I see your note here too. You're classified as a 1B, which for those who are not familiar with trademark law, that means intent to use. So what Chazzy is saying is that rather than already using her mark in interstate commerce, she has said, I intend to use it, so I want to reserve a placeholder, essentially. And then what happens is she has a period of time, I think it's 6 months, to submit evidence, or a specimen is what it's called, but evidence that she's using the mark in interstate commerce. If she's not doing that yet, she can file for an extension and then another extension. There is a limit, but the extensions cost money and they take time. So first off, often my advice to business owners who are looking at doing an intent to use trademark is there any way that we can just get some commerce happening right now? For example, start selling to a few people. I don't care if it's your cousin or your uncle or your aunt, but get some sales done. Get a website out there offering it for sale. If there's a way to get some transactions and some advertising in place, that fulfills the very small requirement that you have some sort of commerce. But let's say it's not possible. For example, it's often not possible if you're going to sell a product that's patented, and you need to file a patent application, which means you also need to come up with a lot of money for the patent attorney fees to file the patent application. So you're not ready to sell it yet. Well, one option is you could start taking pre-orders. That might be a way to go. But just let's hypothetically assume that you can't. And so then intent to use, you file the intent to use application. So back to Chazzy's question here. After filing the intent to use application, two other companies filed similar names. One of them took her labeling layout. So first, what are Chazzy's trademark rights, or what are your trademark rights if you've been using a mark already in business? You have what's called common law trademark rights. That means you have a common law trademark in the counties where you have used the mark. It's not the same as a registered mark where you have nationwide rights or a monopoly on that mark, but you do have rights in the counties where you've been using it. Now, the fact that somebody else copied labeling layout makes me wonder if they are copying what you're doing. And if they are, that may be copyright infringement. Taking a look at a little more detail here from Chazzy. So, because or if you have filed an intent to use application and then you provide specimens showing use in commerce, if the US Trademark Office grants your application and so grants a trademark to you, that trademark is retroactive back to the date you originally filed it. So you would have a first in time, first in right situation. In other words, because you were first, you have first rights to use it. So in conclusion, if you find that once you start, or if you've been using a mark and then you apply for a trademark registration, the best option is to show that use and do a trademark application showing that you are currently using the mark. But if you must use an intent to use mark, then ultimately you want to get that finalized as soon as possible, because then it goes retroactive back to the date of filing if your trademark registration is granted. Okay, I'll move on to the next question here. Are the best CEOs introverts or extroverts? I remember growing up, my dad had a big personality, and one of my uncles had an even bigger personality. And I really enjoyed being in social gatherings with them because they were so fun. They told stories, they cracked jokes, they were the center of attention. And as you're growing up, you're trying to figure out, how can I be better in categories? How can I be a better conversationalist? How can I be more entertaining at social events, etc.? So I determined that I was going to work to improve my social skills, joke telling skills, etc. And I wanted to be very much like my dad or like my uncle, because I just found they brought so much joy and fun to conversations. But honestly, it wasn't natural for me. Whereas with them, it was natural for them. They were just being themselves. And I'll never forget one day when I was driving with, I think, my then fiance, now my wife, Kate. And we were going to a social gathering. And she said, "Hey, just remember, you don't need to be the life of the party." And I shared with her that I really enjoyed how my dad and uncle were the life of the party, and how much joy and just kind of love that they brought to events. And she said to me some really wise words. She said, "Yeah, but you aren't them. That's natural for them. That's who they are. If you try to do that, it comes across as fake or forced. Be yourself, be genuine. It's okay to have thoughtful conversations in a corner. Be yourself. People like you for who you are and who your personality is. And it's awkward if you try to be someone you're not." So, going back to the question of being an extrovert or introvert CEO, I embrace that. And I realize it's better to be who I am than to try to be somebody else. And one time I was the CEO of a company of about 30 employees, maybe 35 at the time. And somebody asked whether my introverted personality was sufficient for the growth that the company was experiencing. And I remember the COO said to that person, uh, actually, some of the best CEOs are introverted. You may not see them on the news, you may not hear about them out there, but some of the best CEOs I've worked with are introverted. I found some comfort in that. But more importantly, as I've thought about that over the years and observed the temperaments of CEOs, founders, and business owners I work with, I've observed that there's a big cross section from introvert to extrovert, from creative to practical nuts and bolts. I remember one CEO I met who was extraordinarily successful. Um, to give you an idea, he would give away millions of dollars every year to charities. So that gives you an idea of how much money was coming in. He was an extreme introvert, kind of an engineer mindset. He built a school. And when he built that school, or before he bought the property for it, he measured precisely how many miles it would be from his office and from his home. And he also drove it multiple times during traffic. Why? Because he was so concerned about measuring how much time am I going to waste every day or spend every day driving between home, work, and school. And he rejected parcels of land because they wouldn't be ideal for him. And he said his rationale, as I understood it, was it won't make a big deal where this school is located by a few miles one way or the other for most people, but it will for me, and my time is necessary to get this off the ground and to grow it. So he was an example of a CEO who was extremely introverted and intentional. In fact, in a conversation I had with him one time, he said to me, "You are welcome to contact me anytime about the subject of this meeting." I was there for a very specific purpose. But he said, sometimes people reach out to me when they're in other roles in the future and they want my involvement in something. He said, I do not appreciate that. I don't ever want to hear from you unless it relates to the subject you're here today. I've observed very successful CEOs who are extroverted can sometimes struggle with the head down work that needs to be done. But one way they cope with that is often they'll bring in other trusted people and they will have a team collaboration to brainstorm and work through those particular issues. I've seen introverts who struggle with the social aspects or requirements of the CEO job. But they often cope with that by being very intentional about where and when they will be for those social settings. They prepare in advance. What are the goals for this? What are the thoughtful conversations that I can have? And they often focus on having more one-on-one conversations rather than group conversations. So the short version is whether you are a CEO who's extroverted or introverted, don't worry, you can be highly successful in your role. But I think the key is being honest about who we are, what our limitations are, and how do we mitigate the weaknesses while maximizing the strengths? So when we have weaknesses, what can we do to make those not have as much of a negative effect on the company? And when we have strengths, how do we maximize those and take those to the next level? For example, if you are a head down introvert type CEO, maximizing that and saying, hey, I don't need to do all these social events. I'm instead going to use my time to grow the company in the areas where I have strengths. All right, let's cover the next question. So this question is essentially this. Can I use a brand name or company name if somebody is already using it in another state? The answer is yes, if you're going to just stay in your state. The answer is no, if they have registered that trademark. So this was a question from Brittany. Basically, she said, there's a person with pretty much the same name as mine. Does it really matter if it's in a different state? They're from Ohio. I'm from Delaware. This is a question she posted on YouTube. So let's play this out. You are a business owner who wants to use a business name, but somebody in another state is using it. Well, first off, you have as long as nobody in your state has used it, you have every right to do that. In fact, it's a county by county analysis. So you are welcome to operate in any county in the United States where somebody else is not already using a confusingly similar name. So that's a name that's either exactly the same or similar enough to be confusing to the general public. So as long as nobody's using a confusingly similar name in your county, you're good to go. You can use that name. This assumes that they have not registered a trademark with the U.S. Patent and Trademark Office. If they've done that, they have nationwide exclusive rights to that name. But one thing to consider is whether you might want to get a registered trademark in the future. If you do, you might have to carve out an exclusion for whether that other company is already using a confusingly similar name or the exact same name. There was a big case about this with Amazon bookstore in Minneapolis and the big Amazon.com bookstore. Minneapolis had a little bookstore called Amazon Bookstore for decades. And then Amazon.com came along. Now, who has nationwide rights? Well, Amazon.com applied for a federal trademark. They would have nationwide rights. But what about this Amazon bookstore operating in Hennepin County, Minnesota? Don't they have rights to keep using their name? The general rule is, yeah, they do. But there are some other pieces to this. First, you have to enforce your rights in order to preserve them. If you neglect to enforce your rights, you may lose the right to have exclusive use of that. Now, ultimately, there was a lawsuit between Amazon.com and the Amazon bookstore in Minneapolis, and they settled. And I believe the settlement was they could continue to operate simultaneously. The Amazon bookstore in Minneapolis would continue to operate just in that geographic area, and Amazon.com could exist everywhere else. But that was a settlement agreement, and parties have a right to settle however they want. If that one had gone to court, it's not real clear how that would have been resolved. So if somebody is using your business name in another state, it's not a problem unless you want to get federal trademark registration rights or the other party does. But otherwise, there's no problem with you operating in different states under the exact same business name. I think this has become more of a challenge with the internet these days because if somebody Googles a particular name, Google has to decide which one do I show first. Now, Google generally will take into account where someone's geographically located and show the business with that name in that geographic location. But since the internet, this has become more of a challenge for companies with the exact same name who don't have federal trademark rights. How do you get federal trademark rights? You just apply for a trademark application with the USPTO, which stands for U.S. Patent and Trademark Office. All right. If you haven't already, you are welcome to follow this channel. If you find that this information is helpful and you'd like more content like this, feel free to follow and you'll get notified by YouTube when other educational videos for business owners come out. All right, let's talk about the next question. What is a venture studio? Let's talk about venture studio basics for beginners. A venture studio is a somewhat new business model. And it's a little bit of a loose definition, but it is generally a company, studio, if you will, that is starting multiple other companies. And they often, the company, the holding company, if you will, the studio, is both funding the different startups as well as providing some degree of guidance, management, and oversight. So the company, for example, would hire a CEO of one startup and a CEO of another startup and a CEO of another startup. They'd bring money to the startups. They would bring expertise. They would align strategic partners, lawyers, accountants, marketing experts, etc. So this is similar to venture capital, where a fund might put money into a concept, and the venture capitalists might actually start up with an incubator, multiple startups. But one of the big differences here is usually in a venture studio, the company owns 100%, with the exception of maybe a small percent going to some of the executives like the president or CEO. Second, in a venture studio, the company, the studio, is much more hands-on in guiding and supporting the CEO and the startups within the venture studio. Why would a CEO or somebody want to work in a venture studio? There are two important considerations. First, a startup has a lot of risks. And when you are trying to start an idea, you need money, you need expertise, you need experience, you need the ability to execute, you need professionals to come alongside. And so if you don't have those or you have to line those up yourself, you have a lot more risk and potential for the business to fail. Also, the startup process will be a lot longer. So in a venture studio, you have all of those pieces lined up. The second consideration is if a startup is very successful, you might make, let's say, $10 million. But a lot of founders realize that whether you make $1 million or let's say $2 million or $10 million doesn't necessarily make a huge difference in your quality of life. I mean, sure, you might have a higher quality yacht, or you might have a yacht instead of renting one. But how much of your life really is changed by having that? Yeah, I'm sure it's fun to go on a yacht once or twice, but that kind of stuff gets old. Or fancy watches or fancy consumer goods. A lot of these things, as business owners, you find that they aren't the things that matter in life. What matters is having loving relationships around you, enjoying nature, having fun with the hobbies and the people and the areas that you love, using your skills to help others and to contribute and to solve problems. There are all sorts of different things that provide satisfaction to us as humans, but having a fancier yacht is rarely one of them. In fact, that's more of the insecure CEO who is trying to prove something to somebody, and often it's people they don't even know. Whereas the confident, secure CEOs and business owners, They're more interested in that which provides real meaning in life and general contentment and true happiness, rather than trying to impress people with the way they spend money. So when you recognize that the difference in quality of life in 10 million and 2 million is very little, often founders will say, hey, look, I would rather share in the upside so that I may not get as wealthy, but there is a far higher likelihood that I will get some wealth for my contribution and experience in this business. The other thing that CEOs or those who work in a venture studio benefit from is the experience of being surrounded by experts who have done this before. When you're starting out in business, it takes a long time to figure stuff out. In fact, that's why I went to law school. I wanted to work alongside CEOs and business owners to learn what really works in law, rather than trying to work my way up and eventually perhaps learn some of that from the leaders in companies. So I'm very grateful for the opportunity that I have to come alongside, and I've now worked with over 1,000 business owners, founders, and CEOs to see what works and what doesn't, and that's what I'm sharing with you here today. The takeaway, though, is that you can get a lot of learning, experience, and value by working in a venture studio. That's why people with great ideas may bring those ideas to a venture studio. Now, why would a venture capital fund or an angel fund or some other group start a venture studio? Generally, the reason is because rather than just putting money into ideas, they want to infuse the ideas and the startups with expertise, guidance, insights, and help navigating these startups, because they know that they are far more likely to get money, a multiple from their investment, if that guidance is available to the startup. So a venture studio provides a lot more than money. It provides the wisdom and insights and relationships needed for a company to achieve success. So for an investor, a venture studio reduces risks and increases the chance of earning a multiple on that. And for that benefit, the venture studio is spending money on various people who are coming alongside and nurturing that startup idea. All right, we have a series of questions now. So I'm going to go through these in somewhat rapid form. And in light of the fact that there's some overlap here, I'm going to do my best to still treat them as independent questions. So if you just listen to one of them, you will still understand what that particular question means. This means that there's going to be some redundancy between these questions, but hopefully that will help you as a business owner better understand the unique aspects of each one of these subtopics. What is the difference between meeting minutes and written actions? In short, meeting minutes are the record of what happened at a meeting of people. A written action is a document that says these people who form like a board of directors or the shareholders have agreed to a specific action. Now, the people at a meeting, like a shareholders meeting, have a right to pass resolutions, and those resolutions would be recorded in the meeting minutes. So sometimes instead of having an actual meeting, the people just sign a written action. So you don't actually have to call a meeting and call attendance and keep minutes of the meeting and have record of the resolution. All you do is grab that resolution, put it over in a written action, and then the people who would normally attend that meeting sign off and say, I support this resolution or this written action. What is a written action of the board of directors? A corporation is governed by a board of directors, usually. If you are the sole owner of a corporation, you might be the only member of the board of directors, but there still is technically a board because corporate law requires a board. So you might be the shareholder, the board member, and the president and CEO. In fact, you might be the only employee in the company, and that's just fine. But in a corporation, you do have a board of directors, even if you haven't necessarily acknowledged that. A written action of the board of directors is a document that says the board members authorized to take a particular action are now taking that action. So, for example, a written action might say, the CEO is hereby directed to establish a bank account at this particular bank for the business. Or the CEO will be held accountable for the following metrics. Or the CEO is removed. Or the director of marketing is hereby terminated. So whatever action can be taken in a company by a particular body, like a board of directors, rather than having a meeting and a resolution passed, you can just have a signed written action. What is a written action of the shareholders? Well, in every corporation, you have the employees, and on top of those are the officers like president, treasurer, and secretary. There might be more. And the officers usually either report to the president, who reports to the board, or the officers may all report to the board. The board is elected by the shareholders. So in a way, the shareholders are the ultimate authority. These are the owners of the company. So because shareholders own the company and they are the ultimate authority, shareholders can sign a written action, assuming it's allowed by the articles and the bylaws of the corporation. Whatever the shareholders could vote on at a meeting, usually the shareholders can put in a written action. I say usually because it's possible for the bylaws to prohibit this. It's important whenever putting together a written action of shareholders to take a look at the bylaws. You want to make sure that written actions are authorized or at least not prohibited in the bylaws of the corporation. What is a written action of the members? Members are owners of an LLC. So a written action of the members is whenever the owners get together and agree on some sort of action that should be taken within the company. Just like if a president said to somebody, we are implementing this particular HR policy, the members of an LLC can say, we are doing this or we are doing that. For example, the president is prohibited from buying any more real estate, or the president will obtain member approval of any future transactions exceeding $100,000. The share or the the members of an LLC are essentially shareholders, but we call them members in the LLC context. So a written action of members in an LLC is simply the members agreeing on some order or some command or some decision. And instead of actually meeting and having a resolution passed, they're just signing off on that. So that is the purpose of a written action in an LLC when it is signed by members of the LLC. Let's talk about written action of a board of governors. What is a written action of board of governors? In an LLC, the board that oversees the company is called a board of governors. In the corporation context, the board is called the board of directors. Well, similarly, in an LLC, the board oversees the company, but in an LLC, it's called the board of governors. So written action of the board of governors is simply when the governors decide, rather than meeting to pass a resolution, they are simply going to sign off on a resolution in writing in a written action. Unless prohibited by the articles, bylaws, or state corporate statutes, written actions are generally enforceable. So in other words, often with current bylaws or bylaws that are used in most companies these days, there is nothing improper about the board using a written action to make a decision in the company rather than actually meeting, discussing, and passing a resolution. What is the difference between LLC meeting minutes and corporation meeting minutes? Generally, there's not much of a difference. They're written in much the same way. There's a philosophy out there that LLCs may not be as accountable for having regular meetings as a corporation. In a corporation, the corporate formalities can be more important to avoid piercing the corporate veil or losing the limited liability provided by the company. I'll talk a little more about that in a little bit, but the gist of this is that the minutes for a meeting in an LLC and a corporation are written the same way, and the same general requirements apply. They have to be authorized or at least not prohibited by the state law governing that type of entity. So for corporations, there's the Corporations Act. For LLCs, there's the LLC Act. And then it can't be prohibited by the articles or bylaws of the particular company you're working with. All right. What is the difference between LLC written actions and corporation written actions? They are really the same. The same requirements apply. You can look at the state laws for your particular type of company and see if there's any reference to written actions and follow those. So the Corporations Act for your state, if you have a corporation, and the LLC Act for your state, if you have an LLC. Often there's a section on written actions there. You should also look at your articles and bylaws. Usually it's in the bylaws. There will be a statement on whether written actions are authorized or prohibited. Are written actions and meeting minutes required for single owner LLCs and corporations? This is a interesting and strongly debated issue by attorneys, because the general rule is that you must follow the corporate formalities, which means having meeting minutes and making decisions. And if you don't follow those, creditors can pierce the corporate veil. In other words, you can have personal liability for the corporation or the LLC's debts. So most lawyers will tell you, you must have meeting minutes at least every so often for a corporation or an LLC. Some people will say quarterly, some people will say annually, but let's think about it. How do you have a meeting with yourself? If you're the sole owner of a corporation and you have a shareholders meeting, what is that? Isn't that just kind of a ridiculous formality to create meeting minutes for that? Well, the law has said it's not a ridiculous formality. A lot of things are merely formalities, but it's those formalities that demonstrate a business owner is following the law and keeping the corporation's affairs separate from the business owner's affairs. So then you might ask, if I don't have annual meeting minutes, does that mean a creditor can pierce the corporate veil, or I would have personal liability? Well, I'll tell you, after practicing law for nearly 20 years, I have never come across a case, and I've looked for it, but I've never come across a case where merely not following formalities resulted in piercing the corporate veil. And specifically, I've never seen a case where just because a company didn't have meeting minutes, the shareholders had personal liability. What I have seen is where that was one of many factors considered by a court in determining that the creditor could pierce the corporate veil, which means the shareholders were personally liable for the debts of the company. But as we'll talk about in a moment with piercing the corporate veil, there are a lot of other factors, and those factors are much more important than having meeting minutes, especially for a single owner LLC or corporation. That said, it's pretty easy to put together meeting minutes. All you have to do is get a free template. I have one online. We'll put a link in the description below that you can find later. And it provides a template of meeting minutes that you can use. Just put those together. I get that it's kind of dumb. You're meeting with yourself, but there's a lot of, or it's a very small investment of time to be able to check that box and say, hey, I followed the corporate formalities here. Okay, let's move on to the next section. Is it legal to pay foreign contractors in cryptocurrency? So here's the setup. A United States company has hired foreign contractors to do some work. Can the US company pay those contractors in cryptocurrency? Well, first, let's start out. There are certain laws that restrict money laundering or funding terrorist activities in other countries. So there's certain types of contractors you're not allowed to pay, whether you use cryptocurrency, US dollars, or some other currency. So that's a separate issue. But assuming that you can pay these foreign workers in US dollars, the question then is it okay to pay them in cryptocurrency? Well, you're in the United States, let's assume, and let's assume you're only subject to United States law because you don't have locations in other countries. In that case, as long as you do things by the according to US law, you're welcome to pay people in cryptocurrency. US law permits payments in cryptocurrency. So there's nothing improper in the United States doing that. Here's where the challenge comes up. It may be that these contractors in other countries want to get paid in cryptocurrency so that their government doesn't know about it and thus cannot tax it. It might also be they want to be paid in cryptocurrency for a legitimate reason, like avoiding any sort of transaction fees, or they just prefer cryptocurrency, or their particular currency in their country suffers from significant high inflation rates. And so they don't want to lose the value of their money through ongoing inflation of their local currency. They want something like cryptocurrency. If you are knowingly paying somebody in a way so that they can avoid taxes, you are contributing to their illegal conduct in that country. And thus, you could have some liability for that illegal conduct in that country. But if you're in the United States, you may not care if you are somehow legally liable over there. For example, if they issued a warrant for your arrest in that country, would it matter to you? Well, if you don't plan to go to that country, it's not going to matter. And by the way, paying somebody in cryptocurrency is unlikely to result in a warrant. What would have to happen is there would need to be an audit of that person. They'd be found liable for tax fraud. You might be named as a co-conspirator, and thus you may have joint liability. And so now a warrant is issued for your arrest. And one thing to keep in mind is some countries have extradition treaties with the United States, which means if that country, if there's a proper legal process for you to be held by their law enforcement or held in a jail there, the United States may honor that process and essentially be willing to extradite you or transfer you to that country. That's an extreme hypothetical, though. The short answer is that in the vast majority of cases, as long as you're complying with U.S. law, there's nothing improper about paying foreign contractors with cryptocurrency. Obviously, in order for you to deduct that as a expense on your federal income tax in the United States, you'll need to figure out what the dollar equivalent is and then have that as part of your accounting records. I always recommend working with a CPA, especially when you're dealing with this sort of stuff. CPAs, the vast majority of time, cost far less than the tax benefits they provide. I usually pay a CPA a minor percentage of the benefit provided by that CEA through tax deductions and other tax benefits. All right, if you haven't already downloaded the exclusive videos that you can get by signing up for my newsletter, I encourage you to do that. Those videos provide educational content to business owners on how to avoid some of the most common problems and biggest misconceptions related to starting a business and growing a business. You can get that at aaronhall.com/free. Not only do you get access to those exclusive videos, but I'll send you other helpful information to help you navigate growing a company in a healthy way that provides balance in life, achieves greater success, and avoids a lot of the problems that can just drain and stress out business owners because they did things the wrong way or didn't fully understand what the law was or what best legal practices were. All right, next question. This question is from Opulenceberg, posted on YouTube. Does an e-commerce store need to register in all 50 states? Let's take a look at the details here. What if my LLC is registered in New York State with a registered agent in that state? This LLC serves as an online e-commerce Spotify store. Do I need a registered agent in all 50 states? Shopify stores like Fashion Nova, Gymshark, Kith, Allbirds, etc. Do they have nationwide registered agents? Well, Billy, thanks for this question. There are a couple considerations here. First, if you are selling to people, you have an opportunity to have a contract in place for those transactions. In that contract, you can specify that if there is a lawsuit, venue needs to be exclusively in your jurisdiction. That way, anyone who enters into a contract with you has to file in that jurisdiction. And if they don't, they've breached the contract. The second thing you can do is have an arbitration provision that requires that the legal action against you be filed in arbitration in your jurisdiction or in your venue. So these are two separate provisions that can force you to find out about a lawsuit in your state, because it forces them to bring that legal action in your state. In most states, but not all, an exclusive venue provision is enforceable, which means if you say in the contract, the only way to sue either party is to start a lawsuit in New York, that's enforceable in most states, but not all. One state that will enforce them is Minnesota, but when I first graduated from law school, Minnesota would not honor an exclusive venue provision. So it is decided state by state. That's where the arbitration clause comes in. The Federal Arbitration Act trumps all state law. And it says if there is an arbitration provision, it shall be followed. And so if you really want to make sure that a dispute must be filed in your state, then an arbitration provision is the safest way to do that. That's one way of getting around, practically speaking, having a registration in every state. But technically, you still are required to have a registration in every state, and that requires having a registered agent in those states. You can pay a service to have a registered agent in all states, but I understand it costs a lot of money, and a lot of small businesses, especially Etsy businesses or Shopify businesses, may not have the money to pay each year to a registered agent service. And practically speaking, if you get sued so rarely, it may not be worth the expense. You might rather just have the risk of not being registered in those states. What's the consequence of not being registered in every state? Well, you might not find out about a lawsuit in that state. Now, if you have a provision in the contract that requires them to file a lawsuit in your state or requires them to file an arbitration in your state, then they're supposed to do that. But let's say hypothetically they don't. And then all of a sudden, in a lawsuit from another state you don't know about comes up, you lose it because you didn't know about it, and now there is a judgment on file in that state against you. That can then be transferred or docketed in or to your local state, and they can then garnish and ultimately levy your bank funds. So that is a risk. It's more of a risk with bigger companies. Now, what do you do with that? If that happened, and I've had clients where that has happened, what we need to do is find a licensed attorney in the state where the lawsuit occurred, and then file a motion to undo the judgment that's there. And part of the basis, there are typically two requirements for that. First, you have substantive defenses that were not raised. So, for example, the arbitration provision would be an important one, and then some others. And then second, you need to have acted promptly once you heard about the lawsuit. So it is possible to get those undone. Practically speaking, here's what most business owners do. They register in the state where they operate. And if they have the guidance of an attorney, they have an exclusive venue provision in all transaction contracts. So like a purchase agreement. Second, they have a arbitration provision in those contracts. And then third, they accept the risk that there might be lawsuits in other states that they may not know about, but they don't want to pay the money to register in all those states, and they don't want to pay the money to maintain a registered agent in all of those states, which means essentially an address at an office or co-working space or law firm where lawsuit papers can physically be handed to somebody. Once you get to a certain size, it makes sense to do that. Once you have a physical location in a state, it certainly makes sense to do that. But practically speaking, that's what a lot of business owners do, even though technically it's not lawful to operate in a state, including making sales in that state, without actually being registered to do business as a foreign entity in that state. All right, I'm taking a look at the next question here. All right. What is piercing the corporate veil? How can you avoid personal liability for your business? Piercing the veil, sometimes called piercing the corporate veil or piercing the limited liability shield, is a doctrine that has allowed courts to hold business owners personally liable for the debts or liabilities of the company. Now, generally speaking, if you own a company, you have limited liability. You are not responsible for the debts or liabilities of the company. What you've put at risk is any money you've invested in it, but you don't have liability beyond that. Now, some states will like Texas, for example, will simply say, look, if you were involved in some sort of fraud as part of the company, because of your involvement, you're personally liable. We don't necessarily need to hold you, hold that the veil is pierced. Rather, we are holding you personally liable for that which you did in the company. But piercing the veil doesn't necessarily require your involvement, but it does require your benefit as a shareholder. Let's talk about it in detail. The general rule is you are not personally liable for debts of an LLC or a corporation. If you have a sole proprietorship, if you have a partnership, you're personally liable. But there are some times where when a court looks at the law, the court may say the wrong outcome would result if we enforced the law here. And that gives rise to the Court of Equity. The Court of Equity existed before the United States was founded. In the UK, there's a court of law and a court of equity. And if a person couldn't get justice in a court of law, they could go appeal to the Court of Equity. And the Court of Equity could provide justice and a different resolution than the judges in the Court of Law could. So the Court of Equity always has been a way to provide justice when the law wouldn't produce a just result. Laws are general. They're not specific. And so they don't always take into account the unique circumstances. And that is why in the United States, our court system incorporates both the court of law and the court of equity. Why is this important? Because related to the court of equity is the doctrine of piercing the veil or piercing the corporate veil. It applies equally to corporations and LLCs. So you could call it piercing the LLC veil. You could call it piercing the LLC shield, limited liability shield. Goes by different names, but piercing the veil is the general concept. Piercing the veil is an equitable remedy. It is not an independent basis for liability. So first you have to show that there's a liability. In other words, a corporation owes money for a debt. Once you show that, and it could be a LLC, once you show that, piercing the veil can apply to allow the personal shareholder or owner of the company to be liable for the corporation's debts. So it's a remedy, it's a way to solve a debt that's already been established. It's not an independent basis for why a corporation could be liable. All right, let's talk about the key elements here. First off, as a foundational matter, a court must find that an inequitable or unjust result would occur if the court doesn't pierce the veil. So the court has to find that it would be unjust not to pierce the veil, that basically somebody has done something wrong and justice would not be served unless they were held liable. That's why for somebody to be liable for piercing the veil usually means they've done something wrong, and typically they did it intentionally wrong. So that would be fraud versus unintentional, like negligent misrepresentation. So the first requirement is that there be a need for piercing the veil, otherwise injustice would result. Let's talk about the second requirement. There needs to be some sort of improper conduct. That might be fraud, misrepresentation, wrongful acts. What are some examples of this? Well, let's say a shareholder who is also president of the company is signing contracts for the company that the shareholder knows the company cannot honor. That would be an example of a wrongful act. So for example, let's say the shareholder or the president who is also a shareholder signs a contract with a customer that says, if you pay us $1 million, we will provide the following services for you for the next year. So the customer pays the $1 million. That $1 million is then paid out as a profit distribution to the shareholder. And then after 3 months, the company doesn't have the means to continue to serve the customer. And so the company stops serving the customer. If a judge looks at that scenario and says, all right, clearly the shareholder, who's president, knew they couldn't perform for a year. They took the money anyway, and they moved that money to the shareholder. The judge could deem that the shareholder or that the company's veil should be pierced. The shareholder should be liable to the customer, and the shareholder must turn over profit distributions to the customer. Why? Because the shareholder did something wrong. The shareholder signed a contract that the shareholder knew could not be fulfilled. So we've talked about an unjust result. That's the first requirement. Second requirement, some sort of wrongful act. The third requirement is the company is somehow treating the shareholder and the company as an alter ego of each other. Usually what this means is there is not a clear delineation between the company and the shareholder. What are some examples? Well, separate bank accounts are one basic example. The shareholder shouldn't be using the company's account for personal purposes, and vice versa. The company shouldn't be using the shareholder's bank account for business expenses. A related area is when an employee is working for two separate companies, but only being paid by one. Both companies can be liable for the acts of the other if they're not clearly delineating which company the payroll is coming from. So if you have an employee working for two separate companies, they should get two paychecks, and the time worked by that employee should be separated by company, and they should be compensated for that time for each company. Another area where courts have held there is not sufficient separation between companies is where one company owns the real estate and the other company uses the real estate, and they're both owned by the same shareholder. They should have a contract between them like normal companies would if they're renting office space or a factory. So if you don't have contracts of some sort between your companies, a corporation can hold that they are, or I'm sorry, a judge can hold that they're alter egos of each other. So when my clients have a holding company and an operating company, I will usually put together a really quick and simple contract between those two companies to check the box that we followed the formality of keeping those companies separate and treating them like separate companies out in the marketplace. I should note that the alter ego is not necessary for piercing the corporate veil, but it is often a factor that's considered. These factors are unique to each state, and so you need to look at each individual state to see what its Supreme Court has held are the factors for finding a veil should be pierced. Finally, there's one more factor that sometimes comes up, and that is extreme undercapitalization. For example, if a business was started with virtually no money and no insurance, and it engaged in high risk, there have been courts that have said the shareholders didn't put adequate money into that company, and so they should not be allowed to avoid liabilities caused by that company. I'll give you an example. There was a owner of a taxi company who decided to set up an LLC for each individual taxi cab. And then the owner did not carry a lot of insurance for those taxi cabs. The idea was if one taxi got into an accident, let's say it hurt people or whatever, although that taxi would be totaled, all the other taxis would be protected from liability, all the other taxis that are owned by this owner. So the court then looked at that case and said, did the owner put sufficient money or have sufficient insurance in that LLC? Now, this particular case, the court said yes. Yes, they did. And so the court would not pierce the corporate veil. But many other jurisdictions, many other states would hold that if a single LLC didn't have much money, and it was known that cars get into accidents, that it was irresponsible, it was reckless, it was against public policy to allow somebody to start a company with the knowledge that accidents occur and not have at least some reasonable amount of insurance or funds in that company to cover the injuries that statistically will occur in a cab company. So that particular case, although it went in favor of the LLC owner and the veil was not pierced, or maybe it was a corporation, I forget. In many other states, that would be a great example of where the company is undercapitalized. So again, this is a state-by-state issue. That is the doctrine of piercing the veil. It generally applies equally to corporations and LLCs, but because it is so state-specific, you need to look at what has the Supreme Court in a particular state held are the elements for piercing the veil in that state. All right. If you find these videos helpful and you're interested in little short videos, little snippets, some of the best excerpts from the videos that we've produced, you can find those by searching for Aaron Hall Attorney on TikTok, on Instagram, and various other social media platforms. So feel free to follow us there, especially if you are interested in that short form content, which is some of the best little snippets of legal questions presented by business owners. I'm going to wrap up. We've been going for about, let's see, 80 minutes now, 85 minutes. I'm Aaron Hall, an attorney for business owners and entrepreneurs. If you would like to get more videos like this, feel free to follow this channel by subscribing. And I encourage everybody to subscribe at aaronhall.com/free. That's where you can get some exclusive videos helping business owners avoid common and expensive legal problems and help grow your company so you achieve success in your company and hopefully as well in your life. Thanks for joining me here today.